Hello everyone! Today we are going to discuss everything you need to know about the anti-child marriage law, the law prohibiting the child marriage and making it illegal in the country, which came to force on January 6, 2022. This is the Republic Act 11596, also known as an act prohibiting the practice of child marriage and imposing penalties for violations thereof. What is this law all about? Section 1 of Republic Act 11596 provides that it is consistent with Section 13, Article 2 of the Philippine Constitution, in which the state recognizes the vital role of the youth in nation building and promotes and protects their physical, moral, spiritual, intellectual, and social well-being. The state shall abolish all traditional and cultural practices and structures that perpetuate discrimination, abuse, and exploitation of children, such as the practice of child marriage. The state affirms that marriage should be entered into only with the free and full consent of capacitated parties, and child betrothal and marriage shall have no legal effect. Pursuant to these policies, the state thus views child marriage as a practice constituting child abuse because it debases, degrades, and demeans children's intrinsic worth and dignity. For us to understand more about this law, we are going to discuss some of the important terms that are used in this act. These terms are defined under Section 3 of RA 11596. First is child. Child in this act shall refer to any human being under 18 years of age or any person 18 years of age or over, but who is unable to fully take care and protect oneself from abuse, neglect, cruelty, exploitation, or discrimination because of a physical or mental disability or condition. Child marriage, which is the main topic of this act. Child marriage refers to any marriage entered into where one or both parties are children, and solemnized in civil or church proceedings or in any recognized traditional, cultural, or customary manner. Guardians. They refer to relatives or individuals taking custody of a child in the absence of the parents or anyone to whom a child is given or left for care or custody, whether permanent or temporary, or persons judicially appointed by a competent court as guardians. Parents refer to biological parents or adoptive parents. Lastly, solemnizing officers. They refer to any persons authorized to officiate a marriage under Executive Order Number 209, the Family Code of the Philippines, or recognized to celebrate marriages by reason of religion, tradition, or customs.
In Section 4, it enumerates the prohibited acts or the unlawful acts, and these are the facilitation of child marriage, solemnization of marriage, and the cohabitation of an adult with a child outside of wedlock. When we say facilitation of child marriage, it refers to any person who causes, fixes, facilitates, or arranges a child marriage shall suffer a penalty of prison mayor in its medium period and a fine of not less than 40,000. If the perpetrator is the ascendant, parent, adoptive parent, step-parent, or guardian of the child, he shall suffer a penalty of prison mayor in its maximum period and a fine of not less than 50,000 and perpetual loss of parental authority. A person who produces, prints, issues, and or distributed a fraudulent or tampered document such as birth certificate for the purpose of misrepresenting the age of a child to facilitate child marriage or evade liability under other laws are also responsible under this law. And if the perpetrator is a public officer, he shall be dismissed from the service and may be perpetually disqualified from holding office at the discretion of the courts. So from this, we can understand that any person, especially the parents of the child who facilitates such marriage, shall be imprisoned and fined and may perpetually lose parental authority over their offspring. Second prohibited act is the solemnization of marriage. So this refers to the solemnizing officer, such as the priest or imam or any other authorized person to solemnize a marriage is likewise penalized under this law. So they shall suffer a penalty of prison mayor in its maximum period and a fine of not less than 50,000. If the solemnizing officer is a public officer, for example, he is a mayor, then he shall be dismissed from the service and may be perpetually disqualified from holding office at the discretion of the courts. The third unlawful act is the cohabitation of an adult with a child outside of wedlock. So here, it does not need any marriage. The fact that they are living as husband and wife and one of the party involved is a minor. Example, the guy is the adult one and the girl is the minor, and they are living together as husband and wife under the same roof, and the public knows about it. It is also punishable under this law. So what is important here is one of the party involved is a minor and he or she is cohabiting with the adult party. So what is clear from this law is that this is defined as a public crime. So this is under section 5 of this law. So that means that any individual, not just the young couple, may initiate the filing of criminal cases against the parents or any person or even the solemnizing officer. So how does this how does RA 11596 impact the tradition customary marriage in our country, or what is the legal effect of a child marriage? So under section 6, the legal effect of a child marriage is it shall be void ab initio. So it banned all form of child marriage. It prohibits all child marriage. So the our Republic Act number 11596, it aims to put an end to traditional and cultural practices of child marriage.